Welcome everyone. In this session, we tackle one of the most intellectually challenging and morally heavy branches of legal study, International Humanitarian Law, or IHL, also known as the Law of Armed Conflict, or LOAC. To the layperson, rules of war sounds like an oxymoron. If war is the breakdown of law, how can law exist within it? But for us lawyers, IHL is the thin line between organized conflict and total barbarism. It is not about if you can go to war, that is jus ad bellum. IHL is jus in bello, the law governing conduct during war, regardless of who started it or why. Our goal in this session is a comprehensive survey. We will look at where these rules come from, when they wake up or are activated, and the 4 core principles that every soldier and commander must live by. IHL isn't found in a single source. It rests on what we call the 2 branches and a massive foundation of custom. The first branch, the Geneva branch, is the protective branch. It focuses on people who are hors de combat, no longer fighting, such as the wounded, the shipwrecked, and the prisoners of war, or POWs. The heart of this is the 4 Geneva Conventions of 1949, which are among the most universally ratified treaties in existence. The second branch is the Hague branch. This is the conduct branch, originating from the Hague Conventions of 1899 and 1907. This law regulates the means and methods of warfare, what weapons you can use and how you can use them. The additional protocols to the Geneva Conventions from 1977 are crucial updates that bridge the gap between Geneva and Hague, modernizing the rules of guerrilla warfare and civilian protection in the age of aerial bombardment. Customary international law is also vital. Even if a state hasn't signed a specific treaty, they are bound by customary law, that is, rules that have become so standard through state practice and opinio juris, or a sense of obligation, that they apply to everyone, everywhere. If you are arguing a case and a treaty is missing, you look to the ICRC's Customary Law Database. A common mistake for students is conflating IHL with International Human Rights Law, or IHRL. They overlap, but they are distinct bodies of law. In application, International Human Rights Law applies at all times, peace and at war. IHL is triggered only by armed conflict. The actors are also different. In International Human Rights Law, the law is governing the relationship between a state and its own people. In IHL, that body of law governs the relationship between belligerents, namely, parties to a conflict. Another important doctrine is lex specialis. In the heat of battle, IHL is often the lex specialis, or specialized law, that governs the actor's behavior. For example, International Human Rights Law says, everyone has a right to life. If a soldier kills an enemy combatant in a fair fight, that's a violation of the right to life under International Human Rights Law. However, it is perfectly legal, as long as all the conditions are met, under IHL. So think of IHL as a specialized set of rules that suspend, in some sense, certain peacetime norms to account for the harsh reality of military necessity. IHL does not apply to a riot, a high-crime neighborhood, or a brief civil disturbance. It only applies during an armed conflict. But how do we define that? The gold standard comes from the ICTY in the Tadic decision from 1995. The court held that an armed conflict exists whenever there is a resort to armed force between states or protracted armed violence between governmental authorities and organized armed groups or between such groups within a state. We divide these into two buckets. First, international armed conflict. Conflict between two or more states. The threshold is very low. Even a single border skirmish can trigger IHL. On the other hand, we have non-international armed conflicts, a conflict between a state and a rebel group or two rebel groups. Here the threshold is higher. You need intensity, more than just a riot, and organization. The armed group needs a command structure and the ability to carry out military operations. If you don't meet the Tadic threshold, you're in the realm of domestic criminal law and international human rights law, not the law of war. Once a war starts, IHL's primary job is to divide the world into two groups, those who can be attacked and those who cannot. Here are a few categories of individuals and some concepts that you should be aware of. First, combatants. Members of the armed forces. They have the right to participate in hostilities, or the combatant's privilege. They can be targeted at any time, unless they surrender or are wounded, but they also get POW status if captured in an international armed conflict. Civilians. Civilians enjoy absolute protection from attack, unless, and for such time, as they take a direct part in hostilities. Direct participation in hostilities is a gray area. If a civilian picks up a rifle and starts shooting, they lose their protection. But does a civilian truck driver delivering food to a base count as directly participating in hostilities? Generally, no. There must be a direct causal link to military harm. Military objectives. You can't just bomb a city to break their spirit. You can only target objects that make an effective contribution to military action, like a munitions factory or a bridge, and whose destruction offers a definite military advantage. At its core, IHL is built upon four concepts: distinction, proportionality, military necessity, and unnecessary suffering or humanity. If you understand these, you understand the spirit of the law. First, distinction. You must distinguish between combatants and civilians and between military objectives and civilian objects. Indiscriminate attacks, like firing unguided rockets into a crowded city, are a fundamental violation of this principle. Second, proportionality. This is the most misunderstood rule. It does not mean you must use the same weapons as your enemy. It means that the incidental loss of civilian life must not be excessive in relation to the concrete and direct military advantage anticipated. It is a balancing test, and it is often agonizing. Third, military necessity. This allows for the measures not forbidden by international law, which are indispensable for securing the complete submission of the enemy. It acknowledges that war involves killing and destruction, but it limits that destruction to what is actually required to win. Fourth, unnecessary suffering or humanity. This applies to the means of war. We don't use weapons that cause superfluous injury. For example, glass grenades, which can't be seen on X-rays, or serrated bayonets. If you achieve the military goal with less suffering, the law requires you to do so. So, why does this all matter to you as a student of international criminal law? Because a grave breach of these rules, a serious violation of the Geneva Conventions or the principles we just discussed, constitutes a war crime. When we talk about the ICC or the tribunals we discussed in the last session, the charges they bring are built on the foundations we laid in today's lesson. If a commander fails to apply the proportionality test, or if a soldier fails to distinguish between a combatant and a civilian, they move from being a lawful belligerent to a potential criminal. The law of armed conflict is a compromise. It acknowledges that humans will fight, but it insists that even in our darkest moments, we remain human.